Hello everyone, today let's talk about section 71 to 74 of the Cybersecurity Act 2020. But before I start, let me ask you this simple question. Whilst having that serious conversation with your friend that you don't want anybody to hear about, that secret that you don't want anybody to hear about, have you ever paused to ask yourself, is the government listening to our conversation or not? Well, that's what section 71 to 74 talks about, and by the time this video ends, you will know whether they do or not. So stay with me. Before we get to the main issue, let's understand these three simple terms the Act uses. 1. Subscriber information. This is who you are as a customer. Your name, your address, and phone number. Traffic data. This is the record of your digital activity. Who you called, when you called, which website you visited, not what you said, just the record that it happened. Content data. This is the actual content of everything. The exact words in your WhatsApp messages, what you said on your phone call, the full text of your email. Someone may ask, can the government just wake up and access these three terms? The answer is no. Under section 71, to access your traffic data, a senior investigative officer must apply to the High Court. It didn't say apply to the police or government official, it says it must apply to the High Court. Under section 73, to access your content data, a designated officer must apply to the High Court with strong evidence, and a judge must approve the request if these three conditions are met. 1. There must be a genuine criminal investigation with real evidence. They can only access what is directly relevant to the investigation. The privacy of innocent people must be protected. The interesting part is, all these will happen in secret without you knowing about it, and you won't be told about it. Let me give you a real scenario. Let's use Kofi as an example. Kofi has been running a fake investment scheme in Accra. He has been collecting money from a lot of people and promising them 50% returns in 2 weeks. A lot of people have invested their money and now they are losing it. The CID and the Cybersecurity Authority are building a case around this. They have bank records and victim statements. They also believe that Kofi is running this scheme through WhatsApp with 3 other people. Under the Act, Section 73, a designated officer applies to the High Court. A judge reviews the evidence and is satisfied that all conditions are met. The warrant is granted. Now, Kofi's WhatsApp messages are read in real time. His calls are recorded. All the instructions he gives his partners in crime are also recorded. Everything used as evidence. In 3 weeks, Kofi is arrested, with everything used against him in court. But wait, there is even more protection. The Act doesn't just stop at granting warrants. Under Section 75, any warrant granted has an expiring date. It's not a permanent license to spy. If the authorities need more time, they need to go back to court and explain why, and all the process will start all over again. Also, in Section 19, the Act creates inspectors. These are independent officers who make sure that the warrant is used for its intended purpose. If the warrant says kidnapping case, it cannot be used to listen to messages about something else. Lastly, in Section 70 to 74, the court orders the service providers, such as Airtel Tigo, MTN, and Telecel, to keep the warrant confidential. If they leak it, they face a fine of 20,000 penalty units. So here is the bottom line. The Cybersecurity Act 2020 does not allow the government to read your private WhatsApp messages. If you are an ordinary Ghanaian, your private chats are safe. The law is not watching you. It is only watching those who want to harm all of us. Share this video and see you next time.